Get it in writing. If you're a business owner, you've probably said that phrase on more occasions than you could count. And what's typically meant by this phrase is to have a contract. Contracts are so important because they clearly define the obligations of each involved party and what rights they have. For real estate transactions, for example, everything has to be in writing. But what happens if you want to transfer your rights and obligations to a new party? Well, one possible solution is a legal framework called a novation. So let's talk about what a novation is, important aspects for a novation to be valid and enforceable, and what happens after novation takes place in today's video. Make sure you like and subscribe to our YouTube channel. I'm attorney Alexis Johnson of AFJ Law Group PLLC, and as I said in the beginning, if you're under a contract and you want to transfer your rights and obligations to a new party, a novation may be a way that that can be achieved. But what is a novation? A novation is the process where an original agreement is terminated and replaced with a new agreement. Only this agreement is going to name a new party in place of one of the original parties. So let me give you an example. A and B have a contract. A has certain rights and obligations under the contract, and so does B. A decides to transfer their rights and obligations to C. So the contract between A and B through novation is terminated, and a new contract with the same rights and obligations that were in the prior contract is created with B and C. A is no longer a party to this contract. B and C are the only parties with the same rights and obligations. So essentially, the new contract is going to have the same terms as the former, and each party is going to have the same benefits and burdens that were under the prior contract. So you may be wondering, why would someone want to do a novation? Well, in the business world, they're fairly common because you'll see things like a parent company wanting to transfer the rights and obligations to a subsidiary. But it's also fairly common in the real estate world. And here's a great example. If you have an apartment and you want to sublet it, you can accomplish that through a novation. But, as most of us know, you have to get approval from your landlord or the leasing agency. And that is an important aspect with any novation. All parties have to agree. So in the example I just gave a moment ago, if A wants to transfer its rights and obligations to C, A, C, and B have to agree in order for a novation to occur. So novations can be simple or they can be more complex, but either way, I would recommend that you work with a business attorney to make sure that your novation will be valid and comply with Michigan law. Once a contract is novated, there are two things likely to happen, and they both are centered on liability concerns. So the outgoing party and the remaining party may agree to some type of release of liability for claims that arise after the date of the new agreement, or they may agree to indemnify each other. But you want to discuss both of these options with your attorney when drafting a novation to ensure that you're protected, whether you're an original party or a new one. If you have questions, please feel free to reach out. My team is ready to help. We can be reached at afjlawgroup.com. Please also like and subscribe to our YouTube channel so that you can continue to receive informative legal videos like this one. Thank you for checking out today's video.